A great sponsor for ACC San Diego. The topic today is DOJ bulk sensitive data transfer rule. I think it's very appropriate given the technology age that we're living in, and we have three great presenters today. I'll just call out their names, but I'll let them introduce themselves. We have Myra Jarowski, Chirag Patel, and Lionel Bushberg from Clark Hill. Would you guys want to take the time to just give a little highlight of what you guys do, and then we can get started into the presentation?
Sure. So thank you to ACC San Diego. My name is Mariah Jaworski. I am a data privacy partner with Clark Hill in San Diego, where I do two things primarily. I counsel clients in compliance with sort of national and global data privacy and cyber regimes. And then I also represent clients in defense of regulatory investigations, primarily brought by state attorney generals. Obviously, in California, we work a lot with Cal Privacy, CART, some of the state task force, and then also with global regulators like the ICO. So we work with businesses to deploy risk mitigation strategies kind of in the digital age. And I'll turn it over to my colleague Shirag to share his introduction.
Hi, everyone. Nice to meet you. My name is Chirag Patel. I am also one of the data privacy partners at Clark Hill. I focus in litigation of all things relating to technology. So, as the times change, we are adapting to the new types of claims that we deal with, but we are dealing with privacy defense cases, right of publicity cases, straight technology disputes, cybersecurity claims, AI disputes, and really whatever the world brings to organizations and defending those types of claims. And I'll pass it over to Lionel.
Hey, thanks. My name is Lionel Bushberg. I'm part of the corporate practice group in San Diego. I specializes in cross-border transactions and so M&A, corporate, at large. And obviously the issue of data privacy, cybersecurity comes, very frequently in M&A deals.
Great. Thanks, Lionel. Shirag, can you go to the next slide, please? Great. So we thought that today would be a good time to talk with you about the Department of Justice's bulk sensitive data transfer rule. And there's really two reasons why this presentation is timely. The first is that the rule has been in effect for 1 year. The regulations actually formally became enforceable on April 7th of 2025. There were some delayed enforcement sort of safe harbors, and some of the more substantive compliance obligations came online in October of 2025. But over the last year, we have done a lot of scope assessments for clients, sort of understanding whether they are in scope for the rules applicability, whether they can modify some of their data handling practices. So there's been a lot of lessons learned over the last year, which we hope to share with you today. And then secondarily, the reason this presentation we think is particularly timely is because although there has not been a federal DOJ enforcement under the rule as of today, there has been the plaintiffs bar in California, the always creative plaintiffs bar in California, has been leveraging the bulk sensitive data transfer rule in bringing new and creative pixel tracking and hardware claims, putative class claims against businesses. So we wanted to sort of alert you to this new and emerging trend that we're seeing with respect to putative class filings. And yes, someone just put in the chat, we will preserve some time at the end of the presentation for Q&A. If you have any questions, feel free to put them directly in the chat and we will try to address them in due time. So to begin with at the top, like how did we get here, right? Where did this rule come from? And what does this rule really require? If there's one thing that you take from today's presentation, it's that the name of the rule, the DOJ Bulk Sensitive Data Transfer Rule, is a complete and total misnomer. Okay, colloquially and in practice, we refer to the rule as the DOJ Data Security Program, and that's a far more, I think, appropriate and accurate description of what the program requires. But when you think about bulk, there's no requirement for bulk. When we start looking at the thresholds, which we'll do on a later slide, you'll see that the thresholds are very low with respect to the volume of data that's potentially implicated. Sensitive data, yes, a lot of genomic, omic, biometric data is targeted by this rule, but so is just general personal data. So sensitive data is a misnomer. And then most importantly, transfer. When we drill down on the rule, it's incredible that the rule itself says, this is the DOJ transfer rule. It's really oriented towards access to data. So again, if there's one thing you take from today, it's that a lot of businesses, I think, have said, well, we don't broker in sensitive data. We don't transfer a lot of sensitive data. We're not going to be in scope for the rule. You really need to drill down on the definitions. And the definitions themselves are much different than the rule would suggest. So how did we get here? The rule actually comes out of a Biden era executive order that was issued in 2024. The order relied on IEPA. IEPA is the Emergency Powers Act. Many of you are probably familiar with IEPA from the Trump administration's recent leveraging of IEPA for purposes of its tariffs initiatives. But in any event, it's important to note that IEPA is really a national security regime. It's geared towards extraordinary national security threats and extraordinary foreign adversary threats. And so while this rule has layers that look like privacy law or layers that look like trade and sanctions law, it is fundamentally a national security law. And so if you're ever kind of scratching your head as to why the rule works as it does, it's because fundamentally it's a national security law. So the order, again, issued in 2024, throughout the last year of the Biden administration, Department of Justice, particularly the National Security Division, went through a rulemaking process. Interestingly, with the new administration, Shrug, please go back. With the new administration, although they had the opportunity to revoke or rescind the rule, they didn't do so. And the reason for that is because there's absolutely bipartisan support for the idea that access to US personal data is a bipartisan issue. So the Trump administration actually not only picked up on the executive order, but issued compliance guidelines, issued FAQs, and indicated that they intend to roll out a program regarding enforcement of the rule entirely. The Department of Justice is very interesting in this regard because the DOJ is acting not just as an enforcer, which is probably how you're familiar with the Department of Justice, and in particular with the National Security Division, right? They have civil and criminal penalty enforcement authority, et cetera. But here, interestingly, the DOJ not only promulgated the rule, so went through a rulemaking process, received notice and public comment, et cetera, but also is acting as a compliance and licensing body. So we'll talk about on some later slides, if you have questions, if you want to obtain a license, a general specific license, you're actually going to be directing that towards the Department of Justice, which is a very unique position for the DOJ to be in. Again, this is not the first prohibition or regulation of sort of data transfers and data handling in the United States. There are other federal laws like PADFA, which is very much geared towards data brokers. But this is absolutely the first very broad rule that applies across industry, and not just to the transfer and transactions of data products, but to the access to data. So it's a much broader application than we see even in PADFA or even in GDPR and other international regimes. Next slide. All right, so just some high-level dates. As mentioned, April 8th of last year, the regulations became effective. There was a bit of a 90-day enforcement delay or grace period that the Department of Justice issued. There is a compliance guide and FAQs that Department of Justice issued in April of last year. If your organization is potentially in scope or considering doing a scope assessment, the compliance guide and FAQs are critical. There's a lot of illustrative examples of data handling and data transfer scenarios, and the department speaks to some of that, which is great. And then, of course, in October of last year, the compliance requirements, with which Lionel will speak to, came online formally. So we are in a point of full enforcement and full applicability of the rule. Next slide. Okay, so what does the rule do? Again, and taking it back a step. The rule, really underlying the rule was this concern that foreign adversaries are not just going to spend their time, hacking into a company or an organization when they can actually go to the open market and just purchase a lot of this information, right? They can broker in information about US persons and US citizens. And according to the Department of Justice, they would do so in order to threaten national security through things like espionage, economic espionage, surveillance, coercion, influence, blackmail, foreign malign influence, etc. So there was this real awareness and concern that countries of concern, in particular China and North Korea and Russia, could gobble up data on US citizens and use that to train some of their artificial intelligence, use that to conduct mass surveillance, use that to even conduct, there's reference to this in the rule, enhanced bioweapon impacts. So real national security issues that are underlying the rule. And the rule fundamentally regulates transactions that involve US personal data, and we'll talk about what US personal data is, and a country of concern or a covered person. The country of concern, if you have any familiarity with like OFAC or sanctions regimes, these are not going to be surprising to you. China, including Hong Kong and Macau, Cuba, Iran, North Korea, Russia, and Venezuela. 95% of the inquiries that we've received over the last year concern commercial relationships with China. I mean, that's just going to be where most businesses need to look closely, is going to be at their relationship with Chinese vendors, with Chinese corporations, potentially their global operational workforce with Chinese employees, etc. So that's where a lot of the focus has been. A covered person under the rule is a foreign person, which is any foreign entity. And that foreign entity, so it can be a Canadian company, it could be a French company, but it becomes a covered person if it is 50% or more owned by a country of concern, if it is organized or chartered under the laws of a country of concern, if it has a primary place of business in a country of concern. If this is a natural person, then we're going to be looking at whether that natural person is an employee or a contractor of a country of concern or another covered person. If that person is primarily a resident of a country of concern, or as a final category, the Attorney General does have the ability, and has not done so yet, but does have the ability to designate individual natural persons as covered persons. So what does all of this mean? What this means is the know your vendor requirements or the know your customer requirements have now gotten very prescriptive. We need, when we look at your data handling practices, or when we look at where data is going externally, it's not just, okay, we know we're trading with a Chinese venture fund or a Chinese subsidiary or affiliate. It's, okay, well, we have this relationship with a Canadian company. The Canadian company is headquartered in Toronto, but it's owned 50% by this foreign Chinese fund, right? There's got to be a really high sort of detailed level of analysis when it comes to vendor and customer identity and verification. So this whole practice, like the majority of the work that we've done over the last year has been really geared towards who are we doing business with, right? What are their corporate makeups? And there are these things that we can just have them contract to. Can we have them rep and warrant if they're a foreign person that they're not owned by this country of concern? Or do we have to ourselves independently verify these factors? The good news is that OFAC and sanctions compliance screening tools, they've existed for many years, and they are becoming DOJ bulk storage rule or DOJ data security program kind of compliant. So there's a lot of existing tools that can really help with this, with some of this know your vendor and know your customer work. But certainly this is the bulk of where your scope assessment will be. Next slide. All right, so what type of US personal data is covered? I said at the onset, and I'll repeat it here, that the bulk and bulk sensitive data is a misnomer. And you can just see on the screen or on the slide deck that we're really talking about small volumes of data. So first of all, the relevant time period for understanding or for calculating our volume threshold is a rolling 12-month period. So we're going to do essentially a 12-month look back from the day of our assessment, and we're going to say, over the last year, have we transferred more than the genomic data, for example, of more than 100 persons to a covered person? 100 genetic or genomic data of 100 persons, I mean, that is minuscule, right? If you're in the life sciences, if you're in the healthcare industry, that's usually something that, depending on your licensing arrangements and agreements, can easily be met. It's the volume is 1,000 US persons for omic data. We're talking about biometric identifiers. That's going to be your fingerprints, your facial recognition technology, your like true biometric iris scans, et cetera, of over 1,000 persons. Precise geolocation data. This is often implicated when we're dealing with apps, when we're dealing with apps that might be used just by our employees or might be used by our consumers and customers, but of only 1,000 US devices. And then most importantly, when we look at the certain covered personal identifiers, so again, nothing about personal identifiers is sensitive as we understand it under like state privacy law. And we'll drill down a little further on exactly what the personal identifiers are. But when we're thinking about the collection volume, it's only 100,000 US persons. And I say that because anyone who engages in the ad tech ecosystem knows that collecting PII from 100,000 US persons is easily achievable in the course of a 12-month period of time. I mean, that's a monthly website traffic, right? That's depending on the types of pixels and where your pixels and other tracking devices are coming from. That is easily bringing your ad tech ecosystem in scope for the rule, depending on, of course, where your ad tech technology providers are located. Incredibly important is the idea that, and again, this is how the rule really differs from privacy rules. Privacy rules almost always, whether it's international like the GDPR or even state privacy, they almost always exempt anonymized data, de-identified data, encrypted data from the scope of the laws. That type of data elements are just completely carved out. They here for the rules application, it does not matter what your security protocols are. It doesn't matter if you anonymize the data, if you de-identify it, if you encrypt it, it is still in scope for the application of the rule. So again, that goes back to this idea that this is a national security and not a privacy law. Excuse me. And again, when we think about genomic and omic data in particular, the Department of Justice and commentary around the rule was very clear that the reason these thresholds are so low is because there has been an assessment that for China to get its hands on the genomic data of 100 US persons, from that alone, they could create genetic profiles of the US population for purposes of advancing their bioweaponry initiatives. So it was intended, particularly among the genomic, omic, and biometric, it was intended that those thresholds be as low as they are. Next slide. Excuse me. So for the covered personal identifiers, excuse me, we're going to be looking at a combination of 2 or more of the following identifiers for any US person. And these are easily achieved. It can be government ID and account numbers like social security numbers, passports, and driver's license. It can be more financial data, but it can also be things like device-based data, right? Just device IDs. It can be advertising IDs. It can be network-based IDs like IP addresses or cookie data, and it can be authentication data. So again, what many of you might be recognizing here by just looking at this is that the ad tech ecosystem is intentionally in scope for the rule. And again, it does not matter if you are deploying or using PETs, privacy enhancing technologies, if you're anonymizing the data, if you're de-identifying it, if you are collecting it at the outset, it doesn't matter what you're doing with it at the back end. It is in scope for the DOJ data security program rule. Next slide. This has been a less of an area of inquiry, at least amongst our client base. But if you are a government contractor, there is a subset of government-related data that's covered under the rule, and that's going to be the specific geolocation data and sensitive personal data that is linked to U.S. government personnel. And that includes employees, it includes contractors, government officials. If this is something that would be potentially relevant to your organization, there are sections of the rule and the guidance devoted to this, so you would have to take a look at that. The DOJ rule also includes like a list of the specific geofence locations. So it's going to be if you're collecting data near these 10 government facilities and you're collecting precise geolocation data around these areas, then that would potentially be in scope as U.S. personal data. So something to take a closer look at if you think, if this is your industry, essentially, if you're a government contractor, if you're located near government personnel. Next slide. All right, so if you know that you have data of U.S. persons, right? You've met that, and you know that you might be engaging in data handling or data transactions with foreign persons that could, under certain scenarios, constitute covered persons, right? Because they're somehow affiliated with or related to a country of concern, then you have two primary, there's four actually different transactions that would be in scope, and then you have two primary obligations with respect to those types of transactions. The first is the rule applies when a U.S. person provides a covered person with the ability to access in-scope data in one of the four following transaction types. The first is going to be a data brokerage transaction, a vendor agreement, an employment agreement, or an investment agreement. And so part of your scope assessment is going to be, are we providing access to this type of data in the context of one of these four relationships? Now, what's really important here, and we said at the outset, this is not about data transfers. The name says data transfer, and that's a misnomer. It's about data access. And what does access mean? The rule defines access to mean the ability to obtain logical or physical access without regard to the application or effect of any security requirements. That is an absurdly broad definition. It does not require actual access be proven. It does not even require that actual access exist. It requires that somewhere within the organization, the ability to access exists, which is really quite incredible in its breadth. And what that also means is that when you're doing your access analysis, so when you're saying, okay, in the context of these relationships that we have, do our employees in China, for example, potentially have access? The access analysis has to be without regard to your security and access controls. So in many instances, and I think this was by design, you're always going to trigger or satisfy the access requirement. To comply or modify around it is by implementing access controls, and the rule itself says the analysis has to be without regard to the access controls that you're implementing. So that's very, very extreme. Next slide. All right, so if you look at the types of transactions, those four types of transactions, the rule lays out a prohibited versus restricted framework for how we should be considering the transactions. If we are engaging in data brokerage transactions, those transactions are prohibited. Oh, period. There is basically nothing that we can do, and we are directed to cease engaging in those types of in-scope data brokerage transactions. So data brokerage with covered persons or with countries of concern, data brokerage with foreign parties that are not covered persons, unless there are onward transfer protections in place, which we'll talk about in another slide. And then fundamentally, any access to bulk human omic data or human biospecimens from which bulk human omic data can be derived is prohibited. And again, the point here is there is not any, I think here the point is, regardless of the legitimacy, the United States Department of Justice does not want our foreign adversaries and these countries of concerns to have access to this type of bulk human omic data and bulk human biospecimens at all, period. So those transfers are prohibited. We'll talk on a later slide about how if you really feel there's a legitimate purpose behind this type of transaction, you can obtain or attempt to obtain a general or specific license from the Department of Justice. But the main intent of the rule is that you cease engaging in these transfers entirely. Now, the subset of restricted transfers are going to be the latter 3 out of the 4, the employment agreement, the vendor agreement, and the investment agreement. And all of these agreements are defined, and there's illusory examples in the rule. You can engage in restricted transfers or restricted transactions, but the way that the rule sets this forth is these 3 types of agreements are prohibited unless you engage or you comply with all of the compliance obligations, which Leonel will talk about further. And if and only if you are able to comply, then it becomes a restricted transaction. So again, the assumption is basically everything's prohibited. The restricted, you can only achieve restricted transfer if you're able to implement a host of pretty intense security and compliance obligations. Next slide. All right, so the main point here is when we think about the 4 types of transactions, we have data brokerage, employment, vendor, and investment. Many organizations understand, okay, maybe we have some exposure when it comes to the last 3, employment, vendors, and interestingly enough, investment is actually where a lot of the attention's been. But most of our clients are like, we know we're not data brokers, right? The definition of data brokerage is so broad that many organizations are likely engaging in data brokerage activities that would bring them in scope for the rule, even though they themselves are not data brokers. They're not registering with any of our state data broker registries. They don't identify or understand themselves to be data brokers, but they are engaging in data licensing arrangements that fit within the rule's definition of data brokerage. So here the rule defines data brokerage to mean the sale of data, the licensing of access to data, or, and this is the important part, similar commercial transactions involving the transfer of data from one person to another, where the recipient did not collect or process the data directly from the individuals linked or linkable to the collected or processed data. So it's, first of all, it's bringing in scope first and third-party licensing, data licensing agreements and arrangements. Second of all, the definition of commercial under the rule is not just a transaction where there is a financial payment, it's a transaction where there is valuable consideration. So when we're thinking about data licensing agreements and we're thinking about giving away IP rights, well, that could very well constitute valuable consideration such that we would be in scope as a data broker. Structured data sets, any type of exchange of data where we're providing a service or providing enhancements to the data, we're providing feedback on the data, data analytics, data verification, any of that could conceivably be in scope because of the breadth of this commercial definition. In practice, we've seen some companies try contractually to clarify, well, this isn't a commercial arrangement, or yes, there is consideration, but it's not of equal value. I think that there's probably ways you can, in good faith, try to contract around being a commercial transaction, especially if you are in the life sciences realm. But if you are outside of that space, and if you are in the ad tech space, if you're just kind of engaging in a more traditional commercial transaction, then it's unlikely to apply. And again, the main point with data brokerage is that it's intended to be and is in fact very broad, and companies that don't sell data could still be in scope. So it's something worth really considering. The onward transfer limitation is probably the most important and overlooked obligation. And that is because the rule requires that any transaction that involves any access to a foreign person the US person, so the company, all of you on the call, right, for your businesses, you must restrict the foreign person, excuse me, from engaging in a subsequent data transfer to a covered person or a country of concern. So what is happening here? In my day-to-day business, I transfer US personal data to Canada, to a Canadian counterpart, to a Canadian affiliate, to a Canadian joint venture company that I'm working with, to a Canadian data licensee. There's so many scenarios where you're transferring data to a company in any other country that's not a country of concern, and that constitutes a foreign person. You now have the obligation to restrict your Canadian counterpart, your French counterpart, from transferring that US personal data onwards to a covered person or a country of concern. So what did the Department of Justice do here? They basically created a regime where they expect you, the US business, to regulate your foreign contracting parties, to regulate their use of the data and to prohibit the onward transfer of that data to other foreign entities, particularly to other covered persons or countries of concern. So they want you in this instance to be the watchdog when it comes to the data that you're transferring to them. So what this means is, even if you're not in scope for the more onerous obligations of the rule, you absolutely need to be updating your contracts to prevent onward transfer. That could be a contractual term already in place, and many times it's not, which is really interesting. So this is something that every business needs to be looking at. Next slide. This is the same, and I just saw a slide that said this is very similar to like export administration regulations, and that's absolutely correct, Deborah. This is very much a OFAC sanctions regime mindset. The best thing that you can do is get to know your trade counterparties, your OFAC, your national security counterparties, because they understand these types of frameworks, and that is absolutely the framework that's being applied via the rule. Okay, and then really quickly, because I want to turn it over to Lionel and to Shrag, but the restricted transfers, this is where the bulk of the scope assessments really are. It's going to be whether I am engaging in a vendor agreement, an investment agreement, or an employment agreement, right, with a covered person. And I can continue to engage in those types of agreements and those types of transactions if I have a program in place and it's documented and I have my policies around it and I'm testing it, and Lionel's going to walk you through all of that, that shows my compliance with the rules security requirements. Now, there's two things to note. The first is that the security requirements are very onerous, and in many instances, like in particularly in the vendor context, the security requirements might be impossible or infeasible to really implement. So I just want to flag that. Like I do think, and we've worked with enough businesses now, that I feel pretty confident that one of the impacts of the rule and one of the intents of the rule is to just get businesses to not engage in certain types of data transfers at all in this context, in the vendor investment and employment space. So some businesses, like we'll work with some businesses and they'll just determine we cannot meet the compliance requirements. We're just not going to engage with this vendor or share this data with this vendor, or we're going to work to kind of modify our data transfer instead of devoting those resources to compliance. So that's just something to keep in mind. Vendors, I mean, when you think about your vendors, you're thinking about your offshore IT functions, you're thinking about your cloud service, you're thinking, like right now there's a lot of interest in your AI training and where that's occurring. International clinical trials if you're in the life sciences. So there's a lot of potential vendor relationships that could be in scope that will need to be scrutinized, and you'll have to have a vendor, like a know your vendor protocol around that. Employment, what's interesting about employment is that a lot of companies, like global operation companies with global workforces, don't employ employees directly in countries of concern, right? They're usually employed through another business. So you're going to be looking at whether or not that other business is itself a covered person. Where we do see employment to be relevant is employment is defined broadly enough to include things like board membership. Even if board membership is not paid, employment can include certain director level kind of functions. So there we've been able to work really on an ad hoc basis or on like an employment by employment basis to advise on how you can limit the access of your board member to this data, or how you can have security protocols in place to make it very clear that this executive or this board member is retained by the US entity, doesn't have access, et cetera. So again, something that you will need to scrutinize. And then probably where the bulk of the attention has been on investment. Direct and indirect investments by countries of concern are completely in scope. The rule does exclude passive investments in theory, but if the foreign entity has access, which again is assumed under the rule, doesn't have to be actual access, it's just the potential for access, then that passive investment can become in scope. So really going to have to scrutinize, really going to have record keeping around investment agreements. And the Department of Justice's final rule has a lot of illustrative examples there that can be very helpful. Next slide. All right, Leonel, I'll turn it over to you. So you've decided that you have a restricted transaction and you want to comply with the compliance requirements so that you can still engage. I'll let you walk us through these.
Yes, hearing about what you described, I would want to start by saying ignorance is bliss, but it is not an option. So we definitely need to, to engage in looking at the specific, security requirements, and also trying to build a robust compliance program. So for restricted transactions, they are prohibited unless there's a business, the business meets specific requirements. And those security requirements that would stem from the Cybersecurity Information Sharing Act of 2015 is where we need to look at. These are rule of securities. Obviously, the CISA is supposed to be the body, in charge and helping U.S. companies. Well, we don't know about the shutdown effect on this agency, but the onus is still on the companies to go about making sure that they meet security requirements. So that means they have to check that there's no prohibited transactions, and they also have to establish a security program with some security measures, and that's where we find in the rules, or at least the comments regarding the rules, that there's a really broad language. It's stated must fully and effectively prevent access. And Maya, you talked about how access is also defined very broadly. It's any potential access would meet the definition. So how to fully and effectively prevent access is nearly impossible if we want to be literal about the interpretation of this language. So one of the things that is certainly important is making sure that you turning all the stones, making sure that there's no weakness in the system, but it's also and I think it's a kind of an holistic approach. It's also about really looking at all the different agreements, trying to recomply with when there's a potential transfer to a foreign person, making sure that there's some contractual safeguards. Next slide, please. So zooming in the compliance requirements, it's really about trying to implement some security program that have and on the a written compliance program that would check a few boxes. Internal compliance controls, so data minimization, access, and key management. Looking at employee the employee roles, also having to do the vendor diligence, looking at all the different access of those, employees and vendors, implementing some contractual safeguards through the contractual language in the agreements. Also, that's part of the compliance program, identifying high-risk system, customer screening. So this is all about trying to look at different angles in the approach of compliance. This is where you have to sit down with all the different stakeholders and look at all the different ways that the system could be breached. That the transaction could flow to a covered person or country. This is really a way to just looking at all the different requirements, making sure that there's a program in place so that you have something to rely on. One of the things that also is important is to have some annual audits that need to be performed by qualified, competent, and independent auditors. So at least once a year. And then if there's any unlawful transfer, then notify DOJ. It's always, the must thing to do to report to DOJ. And so when there's some data transfer, also making sure that it's incorporated into the annual report. And one of the last requirement is the record keeping for at least 10 years.
I'll just jump in and say, with respect to the CISA security program, and some of you on the call might be familiar with this, it is both a data level and organizational level security requirements, and they are exceptionally prescriptive and onerous. So if you are not currently like a government contractor or otherwise in scope for CISA's requirements, it is you'll be able to leverage your existing written security program. There's no doubt about it, but there will absolutely need to be enhancements. And to Lionel's larger point, this idea of can we ever obtain fully and effectively prevention of access, right? I mean, even organizations with real state-of-the-art kind of top line security protocols in place still see access by foreign adversaries and by malicious actors. So I think that's an impossible standard and is really why some organizations are trying to modify around triggering the rule rather than complying with it. Next slide. There are exemptions to the rule, which are worth looking at closely. There's 11 total exemptions. We've put some of them up on the screen, but there are some exemptions for de-identified or pseudonymized data for drug and medical device submissions. There are some kind of clinical research exemptions, or the guidance suggests that clinical research transfers are not in scope. So something that you will need to look at when you're conducting your scope assessment for the rule. It's important to note that the Department of Justice can issue licenses, and those licenses can be general, so they can be for a class of transactions, or they can be specific to one company or one regulated entity. They have not done so to date, and those licenses, certainly if you're looking for a specific or an individual license, they will have conditions, and they intend to be issued rarely and sparingly according to the DOJ guidance. There's also a protocol for DOJ to issue advisory opinions, which I think is really useful. I will say we are aware that some regulated parties have asked the Department of Justice for advisory opinions on the application of the rule in certain contexts, and there have not been advisory opinions issued. So that's been a bit disappointing. And then also, I think we kind of mentioned this at the outset, but just something to be aware of, the Department of Justice and the Attorney General can add additional countries of concern and can name additional covered persons, in particular natural persons. So it's possible that that list increases. There's also a Department of Justice voluntary disclosure program under the rule. I myself started at the Department of Justice, and I'm very familiar with one of their DOJ voluntary disclosure programs. I ordinarily recommend that companies wait until further guidance is issued. So, for example, we're usually going to be looking for a penalty policy. We're going to be looking for specifics on how DOJ would treat voluntary disclosure before we determine whether or not to participate in those programs. Again, that doesn't yet exist. So we're still a little bit in a wait and see approach with respect to some of these kind of adjacent compliance functions and programs under the rule. I will say I'm currently in DC for IAPP. Obviously, we have a lot of connections to counterparties in the National Security Division. My understanding is that it remains an enforcement priority, and I know Shirag is going to talk about that further, but that a lot of the department's attention was diverted to like the Epstein file redactions and other priorities, if you will. So this is still an enforcement priority for the National Security Division, but to reiterate, we haven't seen anything as of today. Shirag, I'll let you take it from here. Oh, and so these are just some illustrative scenarios that we have experience with and that kind of determined we're all in scope. So we'll jump over to enforcement because I think that's more interesting. But the high level here, and this will be in the slide decks that are circulated, is you might not be thinking, well, I have an ad tech partnership with a pixel company that I know has some investment from a Chinese fund, right? Well, guess what? That's likely in scope. Or I've got an investment from a Hong Kong-based investment fund. I use a lot of engineering and development talent in China. I mean, that's been a big one amongst like startups and app developers and coders. They tend to leverage a lot of overseas talent, particularly in China. So there, sometimes you can modify around that. You can look to prevent access, but that's absolutely a use case that is oftentimes in scope. Life science companies are going to have to scrutinize their partnering and licensing regimes. And then we will want to be looking at access to corporate resources by affiliate entities and offices in China. So just some illustrative scenarios that we've worked on and have determined are likely in scope.
So the federal enforcement is being handled by the DOJ and Commerce Department. As Mariah mentioned, the potential enforceability began in July 9 of 2025, subject to the 90-day safe harbor rule. And even then, the DOJ's FAQs make it clear that they could go back to enforcement as back as April, if the party against whom enforcement is sought can't show that they were making good faith efforts toward compliance. The penalties are huge here. So civil monetary fines are up to $368,136 per violation, or twice the value of the transaction. I don't know if there's a great clarity of what per violation means, if that means per transfer, or how that's going to be defined by the DOJ and their enforcement, and then criminal penalties up to $1 million and 20 years of imprisonment for willful violations. There is a knowledge requirement, either actual knowledge or reason to know. But as you can see here, that the enforcement is pretty significant if there is a found violation. As Mariah mentioned, we are only kind of seeing the beginnings of the DOJ kind of ramping up to begin enforcement. I think we've heard and know of subpoenas being issued. Of course, they're issued confidentially, so not all of it is reported. But some of this is attributed to both changes in administration, other enforcement priorities, as Mariah mentioned. But the fact that the enforcement is coming soon is signaled by a lot of the things that are happening. The issuance of final guidelines, the FAQs, and the issuance of a voluntary self-disclosure program. Um, from the civil side, we are now already seeing the plaintiffs bar trying to utilize the bulk privacy rule to bolster claims and ad tech claims. And so, if many of you may be familiar with SIPA claims and ECPA claims that are based off of websites' utilization of different types of analytical tools or ad tech tools. And the places that we're seeing references to this privacy rule is as part of ECPA claims. So under the ECPA claim, there's a party exception that says you can't tap your own communications. However, there's an exception to the exception, which is a party who is wiretapping their own communications can be liable under the ECPA if it's in furtherance of a tort or a crime. And the plaintiff's bar is using this new rule as a way to try to get into the crime tort exception under the ECPA. And so one kind of, there's been at least a handful of these. One of these that we've seen recently, and this is meant to be illustrative of kind of the theories that are being brought by the plaintiff's bar, is a recent claim against Lenovo. So complaint brought claims under SIPA, ECPA, the UCL, CADAFA, and common law. And they bolt this together. As Mariah said repeatedly, this is a national privacy rule, not national security rule, not a privacy rule, but they're trying to put these together to say they're one and the same, and both those themes are raised in this complaint. The reference to the bulk sensitive data rule is specifically as part of the party exception to the ECPA, and they focus on the website's use of kind of the major technologies that are often used on websites, TikTok, Metapixel, Google Analytics, and various other technologies. Again, as Mariah said, the thresholds for the bulk data privacy rule are very easy to meet. They say that those thresholds are met by the transfers, and specifically, they're alleging that these transfers are made to Lenovo's subsidiary that's based in China. Very early on in the litigation, so it'll be interesting to see how these will be dealt with. But this is the trend that we're seeing as far as the utilization of this rule.
So one thing that's interesting here is that there's always the question, like, what came first, right? The chicken or the egg? What came first, the plaintiff's filing or the regulatory enforcement? And here the plaintiff's bar got to it first, and they have primarily focused their use of leveraging the rule against like the ad tech ecosystem. But the Lenovo filing is interesting because it's both against Lenovo for its ad tech deployment and also for its hardware potential access routes, which is an interesting theory. But I mention this only because what we're really looking for, and we see this in other data privacy regimes as well, right? There's so much gray in a lot of our data privacy compliance that when we have those initial enforcement actions and regulators focus on some of those edge cases, sometimes the regulators are like sending a message, okay, yes, directly, ad tech is in scope, right? I think we know life science is in scope. I think we know healthcare is in scope because there's genomic, omic data, et cetera. But a lot of entities in the ad tech space or who deploy ad tech will tell you they still don't think the rule applies to them, regardless of all the other boxes being checked. So it would be really interesting to see if the Department of Justice follows the lead of the plaintiff's bar and brings its first enforcement action against like a traditional data broker or against a traditional player in the ad tech space. So we will all be waiting and seeing for that on that. And the one other question that I got, I'll just jump in with this as well. The one other question that I got that I think a lot of businesses are like, well, this is a rule that was implemented under IEEPA, and we've recently seen with the tariffs that challenges to executive orders under IEEPA have been viable. I think that challenging the data security program rule is going to look a lot different than challenges to like the tariff regimes for multiple reasons, but primarily I also think there's like a reputational issue here as well. Like if you are the first organization that's going to be hit in a federal enforcement, there's going to be bad facts. They're going to have some facts about sharing really sensitive data with China, with North Korea, with Iran right now. And do you really want to be the organization that's like challenging the rules compliance with the APA, right? It's going to look a little different, I think, than what we saw with the tariffs, which were implemented under a similar regime. Next, go ahead, Shrag.
Yeah, and just to sum it up, I think is what does a potential compliance approach look like? I think this looks like the same sort of assessment an organization does as part of any other data compliance program, which is Number one, conduct a scope assessment to determine whether the types of data, the types of access to data, and the volume of data could potentially put the organization into scope for this rule. And so part of that can include creating a customer screening process to determine, whether foreign and covered persons are receiving data or have access to data. What are the high-risk systems? And analyzing employee and vendors who have access to these high-risk systems to determine whether they are potentially covered persons based on, as Mariah mentioned, the ability of data to be forwarded onto covered persons or countries of concern. If there are non-compliant transactions to remediate, and then if you ultimately determine that you're within the scope, I think that turns into everything that Lionel talked about, which is to develop a compliance program, and the key features of that are going to be diligence, record keeping, and reporting.
Great. So thank you so much for having us today, ACC and ACC members. We're obviously available to work through any of these issues further with you or any of the ACC members. And we appreciate your time. Are there any questions? All right.
All right.
I think that you will be getting copies of the slide deck, and you can find all of us on LinkedIn. We're always sharing helpful resources, and the Clark Hill data privacy and security team also has a nice listserv. If you would like to subscribe, please reach out.
Thank you.